Welcome to today's program titled State of the State Reactions Post-Dobbs. At this time, all participants are in listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread and it is required for CLE credit. Copies of the webinar recording materials will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to Diane Digert. Diane, you may begin. Hi, Diane. I think you're still on mute.
Thank you, Megan. I will repeat, thank you, Megan, and thanks everyone for joining us. Welcome to the second webinar in our series of post-Dobbs implications for employers. Hopefully you were able to join us in July for our first webinar, which looked at the issue across many lenses and spectrums, and today's webinar will focus on the various state reactions to the post-Dobbs landscape. So before we dig in, I will have to read you our legal disclaimer. This presentation has been prepared by Seyfarth for informational purposes only. The material discussed during this webinar should not be construed as legal advice or legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer, maybe us, maybe your other lawyer, concerning your own situation and any specific legal questions you may have. So, having said that, let's dig in, look at our agenda. We're going to reveal Seyfarth's 50 state tracker, which has been developed for our large employer clients. Then we'll look at state constitutions across the country, personhood statutes. We'll have an update on secondary liability that we covered somewhat briefly in our first webinar, and then a scattering of active lawsuits around the country. So at this point, I'm going to hand it over to Ben Connolly to talk about our 50 state tracker.
Yeah, thank you, Diane. Appreciate it. And I've been asked to serve as the Vanna White for this portion of our presentation, which is great because I always love when I'm not asked to contribute on anything substantive. Makes my life easier. We referenced this during our initial Dobbs webinar, but one of the things that we've been consistently asked by organizations is if we are going to be tracking what states are doing in this space. And so we wanted to be responsive to that. So we have built what I think is a pretty slick tracking mechanism that's more dynamic than many of the trackers that are out there on the marketplace right now, because it shows you a couple different views, and it's going to continue to be updated as developments occur. Now, one of the things we wanted to focus on specifically in building our tracker was the impact on or the relevance to employers and employer-sponsored group health plans and employers more generally who may be impacted by this decision vis-a-vis how it impacts their employees and how they design their plan in a manner intended to help their employees. So that's one of the things that we think is going to make our tracker unique to some of the more generic ones that are out there in the workplace, is the focus on employers and how this impacts them. In terms of the logistics here, this is going to be a free tracker. There won't be a charge for it. There will be registration to gain access. And it's going to be launched live later, I say this month, later in September, as part of a broader rollout of Seyfarth's Survey Center, which is going to include a host of trackers on various employer-related issues of interest relating to wage law, et cetera. But in advance of that, probably within the next 5 to 10 days, we're going to be sending out to any persons who are registered on any or a mailing list a PDF that shows you what's in the tracker and what it looks like on a static basis. But the live sort of ever developing tracker will be launching later in September. And again, it's free, subject to you just have to register with your email. So this is a glimpse of what it's going to look like. We couldn't do sort of a live demo due to webinar software limitations, but this is what it's going to look like when you're in the map. And so as you can see, it shows you sort of a heat map, if you will, of state actions in this space. And I would just reiterate that our goal here was not to say sort of, here are the states where you can or cannot receive abortion services, but sort of drilling down more on, within those states that are focused on or have abortion restrictions, here's how those restrictions are structured, right? Because we know that from employers' standpoints, they want to know sort of what are the limitations on, or how broadly can these criminal laws be applied, right? Did it just specifically apply to providers, or do they also have an aiding and abetting component that could be construed more broadly by a local prosecutor to focus also on, say, for instance, an employer who offers a travel benefit? We also try to capture things like privacy restrictions or whistleblower provisions, which Chris is going to reference later in the presentation, that could implicate workplace protections for employees who report to law enforcement authorities other employees who may have received abortion services. The other big thing we wanted to focus on here are safe haven protections. And when I say that, that can be construed broadly, so it could include, state constitutional protections for receiving abortions. But really, when we say safe haven in this context, with the focus on employers and employer plans, what we're talking about are state protections that prohibit the disclosure of information to law enforcement attempting to enforce abortion restrictions, or have an anti-extradition provision, or, for instance, have a provision that allows employers who are targeted to countersue for damages. So that's one of the elements that's going to be captured in this tracker that we think makes it somewhat unique. And so this will be your live look when you look at the tracker, but then you can click through on any of these states to find out specifics on what those states provide. And so I know this is probably small text, but drilling down, here's an example, right? Clicking through, you would see what Indiana restricts, what the restriction provides, when it goes into effect, what the attachment point is. So when the criminal provisions attach along the gestational period, and then other considerations. So one of the things we're catching in the other considerations are there legal challenges. So you'll see here we captured that yesterday there was a request for a stay of the implementation of the Indiana law by various Indiana provider groups seeking to get the state Supreme Court to block implementation of this law. So that's what we're going to try and do from a live update standpoint, is to capture those types of developments. And then the final piece I'll show is just on the other end of the extreme, right? California with a safe haven law that protects employers in that state or individuals in that state against enforcement actions, extraterritorial enforcement actions within other states. And one of the things that you'll see when you're going through and looking at these states is we are going to have last confirmed dates so that you can tell how fresh the information is that you're looking at. We're going to try and keep this updated as often as possible, but at least on a weekly basis. But this will allow you to see sort of when the last time is that we've looked at this information. So with that, I'm going to hand it back to Diane to talk about some of the state constitutional issues we're seeing in this space.
Thanks, Ben. As we learned in our past webinar, post-Dobbs, the battleground for abortion rights is returned to the states from the federal government. And of significance is not just what's going on legislatively in the states, but what is protected or not protected under the various state constitutions. So no state constitution right now, as we sit here right now, explicitly gives the right or protections over the right to have an abortion or other reproductive rights. Several states' constitutions, though 11, listed on here on the left side of your slide, actually do explicitly guarantee a right to privacy, though, which is something that is not in the U.S. Constitution. So these state constitutions go a little further than the U.S. Constitution, which found an implied right to privacy, but not an explicit right. So these 11 states here, their constitutions explicitly provide a right to privacy. And because of that, some of those states' constitutions have been found by the courts in those states to cover a right to abortion based on the right to privacy or a concept of the right to make self-determine your own decisions. And those 8 states are Alaska, California, Florida, Kansas, talk about that more in a minute, Massachusetts, Minnesota, Montana, and New Jersey. On the other side, there are states where the Constitution of those states explicitly says abortion is not a protected right. And these are in Alabama, whose Constitution was amended fairly recently in 2018, Louisiana, whose Constitution was amended in 2020 to take away that coverage, Tennessee, which is kind of interesting because the Tennessee amendment was actually a reaction to a court holding in 2000 by a Tennessee court that their Constitution protected a right to abortion. And as a result, in 2014, an amendment was put on the ballot for voters who did vote to take away that covered right under the Constitution of their state. West Virginia is a very similar story. There was a 1993 case in that state that held Constitution was protected, the right to abortion was protected under their Constitution. And then recently in 2018, voters, through a ballot initiative, voted to nullify that right under the West Virginia Constitution. So speaking of ballot initiatives, state constitutions are just much easier to amend than the U.S. federal Constitution, which is a Herculean effort to amend the U.S. Constitution. State constitutions are a little more flexible in that regard. So we've seen quite a bit of activity, even pre-Dobbs. I just mentioned Tennessee, West Virginia, Louisiana as examples of states that modified their constitutions to exclude a protected right to abortion. On the other side, Mississippi, North Dakota, and Oregon, all pre-Dobbs, in those states, there was a ballot initiative that attempted to remove a protected right to abortion under those state constitutions. Sorry, somehow my slides are mysteriously advancing on me. I'm going backwards now. There we go. And under those state constitutions would have tried to either define life as beginning at conception or severely restrict access to abortion. And in all 3 of these states, Mississippi, North Dakota, and Oregon, those initiatives were all defeated at the ballot box, which I thought was pretty interesting given what we know about Mississippi. And we can talk about that a little bit later, but that happened in just 2011 in Mississippi. And then post-Dobbs, we, of course, are seeing a resurgence in that activity as with respect to trying to amend the constitutions of various states. We've been listening to the news. We know what happened in Kansas earlier this month. In Kansas, following a state court decision that the Kansas Constitution did protect the right to an abortion, there was a ballot initiative to try to remove that as a constitutional right and put it back with the legislature. And a lot of, pro and against abortion camps were campaigning about that ballot initiative. And ahead of time, I think most of the polls were showing that it was pretty neck and neck. And then when the, polls closed at the end of the day and the votes were counted, the voters determined by a fairly wide margin, much more than expected, to keep abortion protected under the Kansas Constitution. So that just happened earlier this month. I think it was we'll see, I guess, if that is a bellwether for the rest of the country or unique to Kansas. On the November, and we'll see in November, because on the November ballot, there are four other constitutional amendments on the ballot. Vermont, California, and Michigan all have amendments on their ballot to guarantee some version of personal reproductive autonomy under their state's constitutions. Kentucky also has a ballot on the other side, though, where their ballot initiative specifically attempts to exclude abortion rights as protected under that state constitutions. So that's the approach in those states, all on the ballot in November. So we'll be anxiously waiting to see what happens in those states. In the meantime, there's a number of active lawsuits, and not to take away Ada's thunder and her active lawsuits, most of these are different cases. So in Florida, some overlap a little bit. In Florida, you might be talking about this, consistently since the 1980s, the Florida courts have held that abortion is a protected right under the Florida Constitution. The court has tilted to the right over the years since then, and that is kind of vulnerable now, so that those cases are still winding their way through the Florida courts. So we'll keep an eye on that and see what happens. Mississippi, I mentioned that voter initiative in 2011 that was in response to a 1998 ruling by the Mississippi Supreme Court. Regardless of that court ruling and the voter initiative rejecting the constitutional amendment, Mississippi put in place a 2017 trigger law that is now being challenged in a lawsuit as unconstitutional on the basis of the precedent of the 1998 decision. Again, makeup of that court has changed significantly since then, so that precedent might be vulnerable right now. And then in Michigan, Governor Whitmer has asked the Michigan Supreme Court to recognize that the Michigan Constitution protects the right to abortion and to block a 1931 pre-Roe law that's been on the books, never removed, was ineffective while Roe was in place as unconstitutional, but it's been on the books ever since. The Michigan courts have never explicitly ruled on the issue of whether the Michigan Constitution protects abortion rights or not. So it would be a new decision by that court. And right now, things are pending in Michigan. That 1931 law is not in effect, pending the outcome of that court case. And in Utah, and these are all kind of similar, Utah, Idaho, and Wisconsin, none of the state courts in those jurisdictions have explicitly ruled on whether their state constitutions protect the right to abortion. But there's lawsuits, asking the courts to find that. In Utah, they've actually banned or blocked the abortion ban from taking effect as that case works its way up through the court system. Similarly, in Idaho, there's a lawsuit challenging the trigger law in that state on the basis of the Constitution's explicit right to privacy and equal protection in that state. And in Wisconsin, the Democratic governor and attorney general are asking that state's Supreme Court to determine that the right to abortion is recognized in their constitution. So a lot of activity on the state constitution front where the current battleground is often centered here. So I'm going to now turn it over to Sam to talk about personhood statutes.
Awesome. Thank you so much, Diane, for that great overview. Let me try to slowly advance the slides. I think that was the lesson learned, so we don't get overzealous. Okay, there we go. So there's been a lot of discussion post-Dobbs about what states are going to do. One line, as Diane has just eloquently summarized, is to, just pass out and out abortion bans. Another option, though, is not to focus on abortion, but instead to focus on the rights of the fetus. And the origin of this, and just to give a sense of how hot button this issue is, let me just say there's a scathing editorial in today's New York Times on this exact topic. That's worth a few minutes of your time to read. But the origin of the personhood doctrine, it came from a statement by Justice Blackmun in the majority decision in Roe versus Wade, where he says, the right to privacy and that whole rationale of the court, that wouldn't matter if you recognize that the fetus was a person under the 14th Amendment. Because again, the 14th Amendment says that no state should deprive any person of life, liberty, or property. So beginning in the 70s, this led activists who formed the pro-life movement, that's why it got that name, to really focus on the fact that the fetus is a life, even though it has not taken a breath outside of a womb before. And in Dobbs, the majority decision pointedly did not touch this issue. All they addressed was the right to privacy aspect of Roe, to say that that didn't apply to abortion. But it left open, this question of personhood. Now, it's really important, and I think this is a salient quote, which is why I included it, from Rebecca Kluchin at Cal State in Sacramento, where she said, abortion laws regulate a procedure. fetal personhood laws allow the state to regulate pregnant women. And that's really true because, and we'll talk about this in more detail, but if you think about something like we have laws on the books prohibiting child abuse. So arguably, if a woman doesn't wear a seatbelt and gets into a car accident when she's pregnant, not only would she get a misdemeanor for not wearing a seatbelt, she also could be charged with reckless endangerment of a child. Or if there was some willful attempt, potentially even child abuse. So it just shows how the stakes are raised. Of course, some prognosticators have said, well, if you see what she's eating and you're like, well, you're eating like, fast food, or, you're drinking a beer, that could lead to litigation also. Who knows? That seems rather far-fetched, but it does go to the fact that a lot of these personhood statutes are very broadly written. And for that reason, the most broadly written of these laws, the Arizona law, has been stayed. The Arizona law said that a fetus, which they refer to as an unborn child, has all rights available to persons of the state as of conception. That has been stayed in a filing or in a court order from a few weeks ago. There was an emergency injunction, but that litigation over the constitutionality of that law is still playing out. There was also a Kansas law on personhood, but that was struck down by the prior Kansas State Supreme Court decision that Diane referenced. So as of now, we have 3 personhood laws in effect in the United States, in Georgia, Alabama, and Missouri. The Georgia law is the most expansive, and so that's the one I'm going to focus on. It's also in many ways a blueprint for what other states are trying to do. When I last checked, there were 8 pending personhood statutes. So this is definitely a trend to watch. So what is the Georgia statute? Oh, hold on one second. What does the Georgia statute do? Well, it's gotten a lot of coverage because of a provision in it which says that a woman can claim a tax exemption while pregnant. She can treat her fetus for purposes of state law as a child. It also allows her to receive child support for the medical care and other care of the fetus. So that is the current law. Some important exemptions in the law. Life does not begin at conception under this Georgia law. Rather, it starts at 6 weeks. That is when fetal movement can be first detected on an ultrasound, which some conservative legislators say that that's equivalent to a heartbeat. Scientists disagree and refer to it as fetal movement, but one way or the other, once you can see that movement on an ultrasound at 6 weeks, then you are considered in Georgia to have all rights of any other person in the state. Now, it's important that this does not cover ectopic pregnancies or IVF. Those are expressly excluded because it only talks about fetuses that are growing in a womb being subject to this law. Nevertheless, even with these limitations, the scope of the law is really breathtaking for its impact. And we're going to start unpacking those. But one real fear is that in other countries, specifically Poland, where there used to be a personhood law at the national level, what they saw was a huge increase in pregnant women who died when they miscarried, because they were so fearful of going to the doctor because they would be accused of having an illegal abortion. And they really were in no way no way able to prove that that wasn't the case. There's also clearly racial overtones of this law in terms of enforcement in Georgia. One state legislature said, I'm not worried about Karens being impacted by this law, but I am worried about the Kenishas being impacted. And I think you can see that historically in terms of who is being targeted by state laws that attack choices people make during pregnancy and who does and does not get the benefit of the doubt. Georgia has said they're not looking to target women under this law. They also haven't shown any inclination of wanting to target employers or plans. That said, under the plain text of the law, they clearly could do that. But for right now, the focus is really on trying to root out doctors and other medical providers who are still performing abortions in the state, and a way of attacking them as committing murder would really be what it would be if they were found to have done this. So what are some of the implications of these laws, especially as it relates, in part, how it relates to employers? So one is, if you think about a lot of the benefits that are currently covered, either as medically necessary or as supplemental benefits by a lot of the plans who are listening on this call today, first would be birth control medicines. Now, there are some birth controls that folks have termed abortifacients. That is, they actually destroy an embryo after it's been created. This was something the Supreme Court tacitly recognized in the Hobby Lobby decision, that there are some birth control medicines that cause those. It would not be out of step to see Georgia consistent with this the statute to pass regulations that say that benefit plans in Georgia can't offer those drugs. Another thing that you could see as being prohibited in Georgia would be medications like Plan B, which can medically induce an abortion. Another thing that could be at risk would be IVF. Now, IVF is not specifically at issue. It's excluded from the Georgia law, but other personhood laws that don't have that language, a fetus growing in a womb or an unborn child growing in the womb, and just say an unborn child at any point is, due the same rights as anyone else. That's what the Arizona law said, for example. That would, as a practical matter, outlaw IVF, as it would require the implantation of all of the embryos that are created as part of the IVF process, which would make it functionally impossible to implant for the person trying to have a child. It's also, while medical research in large part at this point, or in heavy part, relies on stem cell technology. For instance, that's how a lot of the COVID vaccines were created, was on fetal stem cells. That would be disallowed under this, because to create those stem cells, an embryo at some point in creating those cell lines had to be destroyed. In terms of practical effects for the pregnant woman, as I mentioned, going to seek an abortion or providing an abortion could be tantamount to murder. In addition, a claim, it would be potential or even likely that a woman who was pregnant and also had a cancer diagnosis and wanted to get chemo would not be able to get chemo within the state of Georgia, because it could be seen as child endangerment to the fetus. So that, potentially is one of the types of things that is obviously was not the focus of the Georgia legislature, but that is, a potential consequence of these rulings, that it's going to be putting medical providers in a really horrible situation to weigh the risk to themselves, because a medical provider could be at risk for providing chemo to a pregnant woman in this example. So what are the takeaways for benefit plans? Again, benefit plans are not being targeted right now. Employers are not being targeted. I think politically at this point, there would be massive backlash if the state tried to go against either pregnant women or employers. Nonetheless, it's an important thing to watch because as a practical, just as a matter of law, your plan as drafted may run afoul of state criminal law. And I know that during the last webinar, we talked about the limitations of ERISA preemption on generally applicable criminal statutes. So things that I know are hot topics today, like travel benefits for abortion and also providing prescription, abortion in pill form. Those are things that, if an employer provides that in its plan, those could potentially run afoul of this Georgia law, at least as written, as aiding and abetting of murder. So if you are in Georgia, this is definitely something to talk to counsel about to see how your plan should move forward. And it's also a trend to really watch as more and more states try to copy what Georgia is doing with these personhood laws. And with that, I'm going to turn it over to Chris.
Hello, everybody. So I'm going to just provide really an update for those that were on the last seminar. As they know, we kind of walked through some secondary liability issues, and we've had a little bit of clarity on that since the last seminar, and we obviously know all of this is evolving. So one of the reasons that the tracker, we hope, will be a real tool and really helpful for those that look to kind of keep abreast of what's going on. So in the prior seminar, it said interstate travel for abortion, will become a necessary and integral part of the post-Roe reality. Well, it has. As we already know, there's been a fair amount of press about travel for abortion care in those states that are prohibiting it. We knew there was some lag time after Dobbs that some of these laws would not go into effect. We also know that some of these trigger laws people have been in the courts looking to see if they can stay the effectiveness of those. But many abortion providers have decided that it's just not worth the risk. And so in those states that we've talked about, they have decided to just shut down operations. In many of those states, they're already, based on prior precedent, had maybe one or two clinics total in the state anyway. And so there was a sense that rather than, again, run that risk, they would simply just shut down. So in certain states, there are women who need this care and they're not going to be able to get it in the state. They have to go to another state. And many of the states, as we talked about last time, have invited, those to cross state lines. We know Illinois, California, some other states have specifically said, we welcome you if you can get to us for this care. There's no current enacted state laws that specifically prohibit travel to another state. And I think this goes to Sam's point that, the states, I think politically and legislatively, are being very, very careful about who they're targeting. So obviously, if there's not an abortion clinic in the state and it's in another state and the laws are directed specifically to the provider and the provider's not in the state, the way to target travel would be to target the mother, or, as we'll talk about, aiding and abetting the funder, the person who agrees to drive them. There could be those that sort of support the movement across state lines. And currently, there's no current enacted state law that specifically prohibits paying. And again, as Sam mentioned, the travel benefit, and as Diane mentioned, the travel benefit, we've seen a lot of companies sort of rally behind that. And to the extent there's strength in numbers, I know there are statistics out there that over 50% of employers are providing some form of benefit, and those numbers seem to be trending more toward providing these benefits than not. And while we saw some activity out of Texas early on and some other states challenging that, we haven't seen any specific legislation certainly enacted, nor have we seen any prosecutor in any state that's been willing to go as far as to actually file a criminal case against any employer at this time. We have seen, though, a lot of noise. Several state legislative constituencies have proposed legislation covering out-of-state conduct. So saying, if you go out to another state and have an abortion, would we potentially challenge you when you come back? Or would we challenge the employer in state providing a benefit? All those things are out there sort of making noise. But again, we haven't seen a prosecution or specific legislation. And then, as Sam mentioned, we have these personhood statutes. So it's protecting the unborn child, both as a person, but then also as a resident of that state. So even going farther than just saying they are a person, they're now a resident of our state. So, for example, if you were to leave a state with an unborn child that's considered a resident, are you subject to kidnapping because you actually took that child out of state without permission or to inflict some harm, and sort of maybe fold in some of those statutes. So we mentioned the last time Bigelow versus Virginia, which is the sort of leading case, and we've seen a lot of citation to this about not being able to restrict travel to another state to obtain an abortion. And we've seen legal scholars sort of on both sides saying, well, how far does Bigelow go? As we mentioned the last time, Bigelow is a First Amendment decision primarily, but there is this dicta or statements in that case that a state actually restricting someone from traveling would potentially not be constitutional. It's a states' rights issue. So we haven't seen any express commentary from any of the Supreme Court justices that were on the side of Dobbs specifically challenging Bigelow. But again, we're dealing with a court that has already seen fit that they could overturn what everyone considered precedent. So while Bigelow is obviously still good law, I think it's something we're keeping a close eye on. And so what I really wanted to specifically talk about in that regard is aiding and abetting legislation is out there. Several states have attempted to implement or considering legislation that would impose criminal or civil liability for aiders and abettors. SB 8, which was the Texas law that gained so much press about civil liability and essentially making people private attorney generals to go after, does have an aiding and abetting component to it. Now, what the contours of aiding and abetting would be, what kind of aiding or abetting you would need to provide. Is it funding? Is it, again, transport? Is it information? Is some of what's being sort of hammered out, both in Texas and in some of these other states. And so, again, I want to focus on South Carolina for today. And again, sort of advertise for the tracker here that, we'll try to keep on top of these. But what's most interesting to us from an aiding and abetting standpoint that we're following very, very closely is a statute like South Carolina 1373, which I've got here in the slide, the specific language in it, and I want to focus on two aspects of this. One is it actually, if enacted, would consider aiding and abetting to actually include providing information. And it would also include hosting or having a website. Our view would be that this would go directly against First Amendment law in that it's informational. We have a lot of clients asking us about, can I provide information? What's the nature of the information I can provide? Can I have a website, whether it's an internal website or an external website? Now, I want everyone to be clear. This is not legislation yet. This is proposed legislation, and whether it would ever be enacted, we're seeing the political tides maybe not be as strong as they were even a month ago. Obviously, the midterm elections will have a lot to do with this and how far these state legislatures could go. But we do want our clients to understand, and we want people to understand that there is at least noise out there from some of these farther right constituencies and pro-life constituencies in these state legislatures to actually restrict not just money, travel, but actually information. And providing that information, providing a website, might be something that states might try to target going forward. So again, we're just keeping an eye on this, but it just shows how extreme this could be. And importantly, the informational restrictions, like I said, would clearly seem to run afoul of Bigelow. But there is a case, U.S. versus Edge Broadcasting, which was about lotteries. And it's a Supreme Court case from 1993, 7-2 decision. And in essence, the claim was, could an out-of-state lottery, it had to do on the Virginia-North Carolina border, advertise their state lottery into the state neighboring state where the neighboring state didn't have a lottery, but the other state did, knowing that they're advertising into that state, 50 miles, 20 miles, close enough where someone could just drive across and participate in the lottery in the other state. So you can see where some of this could, fit with kind of the idea of, if I'm in a neighboring state that an abortion is legal, and I'm advertising into a state next to me where it's not legal, and I'm encouraging people to cross state lines to participate in this, could they make an argument that this is on all fours with Edge Broadcasting? Maybe, but probably a difficult argument, because Edge Broadcasting had to do with federal law. It had to do with the FCC. It had to do with significant federal broadcasting law. And here we know, at least under the current administration, and I even suspect under either, even a Republican administration, given the sensitivities of this issue at a federal level, it seems hard pressed that there'd be any federal legislation that would be, consistent with this. So it would really, again, come back to a states' rights issue and a state versus state issue. And, every state is entitled to legislate what's legal and not legal in its own state. So would another state trying to ban this infringe enough on another state with no federal overlay, assume no federal statement either way? I think this is something that, would have a very steep hill to climb, but it's something, again, we're going to pay attention to and make sure, that we're staying on top of it at this point. Again, right now, no current legislation this way, but something that we're keeping an eye on. And then finally, as Ben mentioned, whistleblowers, many of these statutes and proposed statutes, the South Carolina law, Texas law, some other laws, Louisiana, have whistleblower provisions. So they essentially are going to empower, if they're enacted, employees to essentially inform on co-employees or employers or providers because they have bounty provisions that would allow someone to actually get a bounty if they report someone for violating these anti-abortion statutes. So again, that's something we're also tracking. We're not aware of any whistleblower coming forward at this point. We are aware of certainly comments and certainly legislatures putting out that they've heard from constituencies, that they've heard from their constituents about certain things happening. But again, it's something that we're going to look at, because it may be another way that an employee could be empowered, that they might have rights that they don't otherwise have relative to these whistleblowing statutes to be protected. So again, something we'll look at. So with that, I will then turn it over to Ada.
Thanks, Chris. So as you've heard, there's a tremendous amount of litigation in every state considering this issue. So I'm just going to touch on a few. And essentially, the common theme with all the litigation we're seeing right now is that it's the first round. It's the first attempt in a number of cases to stall the effective date, for example, of trigger laws, or to postpone, there are laws on the books, as has been discussed, from the 1930s and even the 1800s that are going into effect. So there are various lawsuits that have sought injunctive relief, attempting to postpone the implementation of those laws. So what we're seeing here, and what we'll talk about in this smattering of cases that I've got, are the states in which that first round of litigation has gone through. That typically means that there is still a round of litigation pending on the merits that are being talked about. So what's happened in this first round is that courts, and they're coming out all different sorts of ways, have concluded that either the chance of prevailing on the merits is low. That's one factor in injunctive relief. Another factor is the burden on the defendant if the injunctive relief is not granted. And the courts, again, are coming out differently on that as well. So the first case, and I know we've talked about some of these, so I won't belabor in too much detail, but the first state I want to talk about is Florida. Here we've seen, as we have in many states, sort of a back and forth on whether the law goes into effect or not. In Florida, at the first level, a judge entered injunctive relief prohibiting the implementation of this law. Then it was appealed, and the appellate court reversed that holding. And I've been trying to check these sort of up to the minute because they change by the minute. So what that means is this spring 2022 law that was on the books remains in effect. And the Illinois Supreme Court is considering whether to affirm the lower court's ruling that injunctive relief is not warranted or reverse that. And what has currently bubbled up to that level is a lawsuit filed by a number of providers of abortion services. So each of these slides here talks about the penalties. These are very, in some cases, very serious penalties. We'll get to Michigan where they talk about if the woman is affected, dies because of the process that was initiated, you'll be charged with manslaughter. So you can see that providers and employers who offer services offer travel benefits should be watching very carefully what's happening in these states. And that's why we have the tracker, and we're trying to be up to the minute on this because every day something new is happening. So that's what's going on in Florida. I will say, so the last column there, it says currently 2 lawsuits are pending brought by rabbis challenging the act as a violation of the First and 14th Amendments. So this is a somewhat new argument that has not been brought to the table about religious freedom and religious rights contradicting the law that's in place. And it's actually up to 5 lawsuits at this point. So none of them have, as I recall, sought injunctive relief to stay the law that prohibits abortions after 15 weeks, which is currently on the books. But we'll see those work their way through the court system. And Sam talked quite a bit about Georgia and the uniqueness of that personhood law on the books there. Again, penalties are quite severe. So everyone who is a provider has been watching this very closely. There were anecdotal reports that in the morning the clinic was open, and then in the afternoon they shut down after a reversal, in this case by the 11th Circuit, which acted earlier than had been anticipated. So this is a law that was on the books in 2019 to take effect in 2020. It was stayed at the time by a federal district court. Then it was continued to be stayed, but the 11th Circuit, and it was appealed up. The 11th Circuit jumped in and reversed and allowed the statute to take effect immediately. We are seeing that there are cues and ties, and a lot of these decisions are coming out based on what the political makeup, I would say, of the Supreme Courts and some of the other committees and things that are involved in evaluating these. So we'll talk, Michigan is one that comes to mind that we'll talk about in just a second. So Michigan is interesting. There's a 1931 law in the books there that criminalizes abortion in basically all instances. It went into effect immediately after the Dobbs decision. And this is the one that has sort of manslaughter and very felony conviction penalties. Most of them are at the felony level. So this one has also wound its way through, and it is currently stayed by a Michigan appellate court who said, look, we've got this referendum on the ballot in November. I'm going to stay the implementation of this 1931 law until after we see the results of the referendum. There were judges before him who declined to do that. So today, actually, they were live streaming the Board of State Canvassers in Michigan, which was, as some of you may recall, subject to some controversy in that some of these same canvassers refused to certify election results, resulting in ousting of membership and that sort of thing. So there are 2 Democrats and 2 Republicans on this board that need to vote to decide whether the referendum protecting abortion rights will be able to be on the ballot or not. And my understanding is they're deciding that today. So as of a few minutes ago, still not decided. If they tie, then it goes up to the Michigan Supreme Court to decide whether that referendum goes on the ballot. The next state is Kentucky. And again, this is another state that had a trigger law that was in effect. The law provides that all abortions are illegal unless a woman or other pregnant individual is at risk of death or serious permanent injury. That's a nuance there that is different in different states and worth paying attention to from a provider perspective. Again, felony criminal liability. This law has been reinstituted after a lower court temporarily halted it. Now, again, this is the injunctive relief portion. They're going to continue to litigate the merits of whether they could succeed, but this is, an early sign that the court is finding that potentially the challenger to the abortion law will not succeed. When I got ahead of myself. All right, and Texas we've talked a lot about. Again, here we're seeing some efforts by the Attorney General Paxton of Texas that are unusual and are really bellwethers for what we may see in other states. The one I want to highlight here is that Attorney General Paxton sued the Department of Health and Human Services over guidance that it issued indicating that if emergency treatment was required and that it required abortion services, that would preempt or overrule any limitation in state law on providing abortion services. So Paxton sued, as I said, and again, they sought initial injunctive relief. The federal district court out of the Northern District of Texas concluded that injunctive relief was warranted. So in this instance, they stayed the implementation of this Health and Human Services guidance. And the rationale provided is there. And then we have literally the exact opposite outcome in Idaho. We had the Biden administration sue the state there, saying that their abortion law went afoul of EMTALA, again, which is a law that requires emergency services be provided. And in that instance, the federal district court concluded that there was harm, that there was a conflict, and stayed the implementation of that law. We do expect that to continue to make its way through the courts. So we will continue to see a host of litigation around these issues, and we'll continue to update you. With that, I'll hand it back to Diane.
One point I just wanted to flag before I just wanted to flag one point, Diane, if that's okay. One other potential effect for employers of the personhood laws is it could potentially impact visas that your immigrant employees are eligible for. Because if you're carrying a child who's recognized as a person already in that state, that might have implications for what type of visa you could potentially be eligible for. So just wanted to flag that. I forgot to mention it before.
Thanks, Sam. I'm going to give the CLE code for those of you who are looking for continued legal education credits for this webinar. It is SS, stands for Seyfarth Shaw, SS1289. So again, SS1289 is the CLE code. I don't see any audience questions right now. Please feel free to submit your chat questions. I'll my one commentary while we wait to see if any come in is, when I was talking about constitutional challenges, my slides were created before the constitutional challenge in Indiana took effect, but then you capture that in the tracker. So I think the tracker is, updating in real time, and can't wait to see that launched, and hopefully you'll all be able to take advantage of that. I have been asked to reread the CLE code, so I will do that. Again, it is SS1289. SS1289. And any final thoughts? Thank you for spending the last hour with us. We should be back to you in another month with another webinar in our series. Oh, I have a question about the tracker. Ben, will clients be invited to subscribe to the tracker?
Yeah, I can take that one. Yeah, it's not just clients, right? This is anyone on our email list. There will be or on any of our email lists, I presume, there will be an announcement that we're launching the Survey Center and an invitation to sign up to subscribe. So if you're on our email lists, you'll get that announcement. If not, we have a reproductive health landing page on our website, www.seyfarth.com, which will have information on how to subscribe once the tracker is going live. Again, the only hang up here is that we're rolling it out as part of the broader survey center. So that's what we're finalizing that. So some of the other surveys there, but in the interim, if you are signed up to our listservs, any of our listservs, you'll get the announcement of the tracker as well as a PDF of all of the data available to date on the tracker.
And I see, and I think Megan has
Yeah,
answered someone asking for slides afterwards, but you can also find copies of our materials and our blog posts, and our articles, and our webinars on our Seyfarth.com website. Again, as soon as you log on there, you'll see the landing page is the Reproductive Healthcare Advisory Team, and a link to all these materials, including the survey.
Perfect. This concludes today's webinar. Thank you for attending.